Joining us now is Chris Oxtoby from the Freedom Under Law. He's a research consultant there. Thank you so much for joining us, Chris. Now, Freedom Under Law was one of the applicants to this application to the High Court. The MK Party has put out a statement with regards to the indictment of Dr. John Hlophe, and it reads as follows. It says, the incompetent, irrational, absurd and blatantly political judgment of the Western Cape High Court, which is regrettable, is not surprising. What's your reaction to this ruling? Are you satisfied?
Yes, I mean, I think the bottom line is that there were a great deal of concerns, as we've heard already, about the prospect of someone who has been found unfit to be a judge sitting on the JSC, being involved in the process of appointing other judges. That's really the nub of the issue. So the fact that the court has interdicted to make sure that at least that does not happen at the JSC's sitting next month is a positive development. Freedom Under Law had approached the matter a bit differently to how the other parties, the Democratic Alliance and Corruption Watch, had approached it, where we were asking immediately for final relief, and the court chose to postpone that particular application. So, the case is still ongoing, and we'll wait with interest to see how that application is going to be determined, together with the final application for relief from the other two parties. But in the immediate term, I think it was very important that we did not have a situation where Dr. Hlophe sat on the JSC next month, given all these concerns. So we welcome the fact that at least that interdict prevents that from happening.
And with regards to Dr. Hlophe sitting next month, within the statement, the MK Party says the court simply ignored Section 178 of the Constitution, which requires that 3 members of the opposition parties be appointed to serve on the JSC. And that means currently we've got Action SA and EFF, and if Dr. John Hlophe does not sit, then that would mean that the MK Party is not a part of that. So as Freedom Under Law, in terms of your final relief, are you open to any other member of the MK Party sitting in the interim?
Yeah, I mean, it is important to emphasize the point that the concerns were specifically directed at the fact that it was Dr. Hlophe, bearing in mind that he was removed as a judge, that he was found unfit for judicial office. Our case has not been that political party is not entitled to put a representative on the JSC. That's never been our argument. The concern is particularly about Dr. Hlophe, about his past status as a judge and the circumstances under which he was removed from office. And we argue that in terms of other provisions of the Constitution, such as Section 165(4), made it not just unsuitable, but in fact unlawful for him to sit on the JSC. So it's not a party-wide objection. It's a very specific objection to that one nominee that we've raised.
How does the interdict preventing Dr. John Hlophe from engaging in the JSC activities reflect broadly on the efforts to safeguard the credibility and impartiality of the judicial system?
I think it's a very important, it's an important step in that process. Obviously, as we've said, the final, the second phase of the applications will still have to be heard. So as I say, the process is not over. But this is an important step to safeguard and preserve the integrity of the judiciary, of the appointment system. And in fact, it's something that the court noted in its judgment, when it said that if Dr. Hlophe were to sit, then the harm that would follow from that is not capable of being undone. And of course, the next month's sitting of the JSC has some, very pertinent vacancies, including his replacement as Judge President at the Western Cape High Court is being interviewed for. So I think it was really important that one way or the other, we did not have a situation where, in light of the concerns about him, he sat in next month's interview. So the interdict is a very important aspect of protecting the integrity of the judicial appointment system.
Going back to the MK Party's statement, they have a reference here where they say the DA is now colluding with Freedom Under Law, which is yourselves, and Corruption Watch, racist agents of white monopoly capital masquerading as civic organizations who want to usurp the power of the legislature using the judiciary. Speak to us perhaps about the role that the Freedom Under Law has in playing in promoting judicial accountability, transparency, and ethical behavior within the legal profession.
Well, I think the organization has a long history of upholding all of those principles. It's had a long history of litigating and advocating for protecting against, frankly, failures of governance, failures of accountability. It would be very nice not to have to litigate an issue like that, but unfortunately, it has on occasions been necessary for organisations such as ourselves and other organisations to turn to the courts to make sure that our constitutional democracy and our structures of governance are protected. And that's really the bottom line, and that's certainly the view that the court itself appears to have taken of the matter in this case.
Lastly, Chris, Parliament supported the inclusion of Dr. Hlophe in the JSC despite his impeachment. Do you believe a change in how the National Assembly selects individuals for such committees and commissions needs to be reviewed?
I think so. I think that's clear from what the court has said in its judgment today, and of course we'll wait to see what the courts say about the matter subsequently. But one of the points that the court made in deciding that there was a prima facie right which justified the granting of the interdict was that the members of Parliament had incorrectly assumed that they had no discretion but to accept the MK Party's nomination of Dr. Hlophe, regardless of these concerns about his particular background. And I think the court clearly seems to agree that was a mistake. That was a mistake of law that the National Assembly made. And so, yes, that very much suggests that particular practice is something that will have to be re-looked at. In fairness to the National Assembly, it is, as we've heard, unprecedented territory where these kind of objections have not been raised before. But I think it certainly is important that the lessons are learned from that to avoid the situation repeating itself in the future.